And a very good day to you from Australia. My name is Ruth. I am an Australian registered migration agent and a solicitor or lawyer of the Supreme Court in our state and the High Court of Australia. In this video, I will be sharing with you the new Skilled Employer Sponsored Regional Provisional Visa, subclass 494. Now, I note that the information in this video is not to be treated as legal advice, but it will give you vital information concerning the 494 visa. So let's get started. Currently, the 4 definitions of regional across 9 different skilled migration visa. Now these will be replaced with one simplified definition from November. And regional area will encompass all of Australia except Brisbane and Gold Coast, Melbourne, Perth and Sydney. So anywhere else outside the places that I've mentioned will now be considered as regional Australia, which is fantastic because applicants and employers now will have further and greater opportunities for sponsorship. The subclass 494 visa program will be incorporated into the standard business sponsorship framework. There will be no separate sponsorship class created. Existing SBS will be able to lodge an SESR nomination. Now, sponsorship obligations will of course apply to employers, and some of the regulations have also been amended. There are 2 streams. The first one is the employer-sponsored stream, and the second one is the labor agreement stream. And there are 3 stages to the application, which are sponsorship, nomination, visa application. So in regard to the nomination requirement, applicants or employers are invited to lodge online. There will be no nomination fee for employers because it's in the regional area. Now applicants must be an approved sponsor before they can nominate a worker. SBS is for Australian businesses only. Party to a labour agreement that authorises subclass 494 visas can also apply. The position must be located in a designated regional area. The occupation must be specified in the relevant occupation list or in the labour agreement, and any caveats must be met. The position must be a genuine position. Labour market testing must be undertaken, and in this program, no international trade exemptions will apply. It has to be a full-time position, no provisions to disregard. The annual market salary rate requirement must also be met. No information that the employment conditions are less favorable than for an Australian worker must also be met. In regard to the nomination, the workers must be engaged as an employee under a written contract of employment unless exempted. Associated entity provisions will also apply. The sponsor must not engage in discriminatory recruitment practices. SAF contribution must be paid. So even though the application fee is nil, the SAF contribution must be paid. So it would be $3,000 for small businesses or $5,000 for other businesses, and it is payable at the time of application. A pro rata SAF levy may also be applicable if nomination is for a 494 holder to change employer, and this must be provided at visa grant date. Regional certifying body certification must be provided regarding AMSR. So that still applies. And immigration must find that the employer does not have any other adverse information which would cause them to refuse the application. So those are the requirements for the employer to nominate a worker. Now let's go to visa applicants. So here are some of the requirements. Firstly, there's no adverse information about the sponsor. The applicant must be under 45 at the time of application. The application must show that there's an approved subclass 494 nomination that has not ceased in the correct stream. And if the applicant is in Australia, they must hold a substantive visa or a bridging visa A, B, or C. And they must show that they have successful skill assessment at the time of application. So this is a greater obligation placed on applicants in comparison to other types of visas. There must be a genuine intention to perform the occupation. The applicant must have at least 3 years of full-time relevant experience in the nominated occupation or a related field at the same level of skill. So 3 years of work experience is vital. The applicant must show competent English at the time of application. So that's a pretty high standard. They must also meet health and character requirements, and one fails, all fails criteria will apply. So for example, if one of the family members cannot meet the health requirement, then it would be a one fail, all fail requirement. That would apply. Australian values will apply to all applicants who are 16 and over, and members of the family unit are listed in the nomination or sponsor has agreed to include in writing. So if you wish to bring your families, then the sponsor must have agreed in writing or they are listed on the nomination application. So in regard to the transitional arrangement, no new RSMS direct entry application subclass 187 will be able to be lodged from the 16th of November 2019. So essentially the 494 visa will be replacing the 187 visa application. However, RSMS temporary residency transition applications may still be lodged if the nominee is either a transitional 457 worker or a transitional 482 worker. So, for example, if you currently hold a 457 or 482 visa, then you may still be able to lodge an RSMS 187, but under the temporary residency transition stream and not the direct entry stream. RSMS nominations lodged before 16 of November 2019 where the nomination has not been approved or refused before the 16th of November 2019 and the nominee is not a transitional 457 or 482 worker and the nominee has not lodged a subclass 187 visa application before the 16th of November 2019 are taken to be withdrawn on 16 November 2019. So if you're looking at lodging an application under the current laws with 187, then you need to lodge it before the 16th of November 2019. Okay? Alright, now I would like to just share a little bit on the permanent residency pathway under the 494 visa. So the new permanent residency skilled regional subclass 191 visa will come into effect on the 16th of November 2022. So that's 3 years after the introduction in November this year. So here are the key requirements. Firstly, the primary applicant must have held a regional provisional visa for at least 3 years. The primary applicant must have earned a minimum taxable income for 3 years as the holder of a regional provisional visa. So in terms of the income level, it is still yet to be determined by the minister, but we will hear more in the upcoming months, I believe. The applicant must also have complied with the conditions of regional provisional visa, particularly the requirement to live, work and study in a designated regional area of Australia. And applicants can also apply for a subclass 189 or 190, which are the other skilled visas, but you can only apply after 3 years if you're invited to apply. So if you're a holder of this visa, then you can only apply for those after 3 years of holding the visa. Now that brings me to the end of my video. Now the information in this video are general information only. Please do not treat them as legal advice. We assess each case on a case-by-case basis. With the ever-changing laws of immigration, it is vital that you obtain legal advice or migration advice that suits your situation. Now, if you require advice on how to proceed with your case, please do not hesitate to contact us on the email address below, and we would be happy to assist. We wish you the very best in your future endeavors. Thank you.